All right, we're at the International Criminal Court in The Hague, and a really crucial hearing is unfolding. The prosecution has laid out its case against former Philippine President Rodrigo Duterte. But now, it's day 3, and the spotlight is swinging over entirely to the defense.
So today is all about the defense's side of the story. They're led by lawyer Nicholas Kaufman, and their job is to try and systematically pick apart the prosecution's case. And they're not just arguing over little details, they're going after the very foundation of this entire investigation.
And their first argument is a big one. Kaufman basically claims that this whole process wasn't some neutral search for the truth. He's alleging the ICC engaged in what he calls a priori targeting. What does that mean? Well, essentially that they decided on a guilty narrative first and then went looking for evidence to fit it, instead of letting the evidence lead the way.
And that brings us to one of the absolute crunch points of this whole hearing. A huge part of the defense's case really boils down to how you interpret a single word found in official police documents. It's a word the prosecution says was basically a license to kill.
And that word is neutralization. You see it in the paperwork for the anti-drug campaign, Project Double Barrel. For the prosecution, this is it. This is the linguistic smoking gun. Coded language that they believe gave police the green light to carry out extrajudicial killings.
So as you can imagine, how you define this word is absolutely critical. The prosecution sees this dark hidden meaning, but the defense? They offer a completely different reading. Kaufman argues, hey, neutralization is standard police jargon. You know, it covers everything from a lawful arrest to subduing a suspect. He insists that government documents actually show it means to incapacitate suspects, yes, but within the law, not to execute them.
This whole battle over one word leads right into the defense's next major challenge for the prosecution. They're basically saying, prove it. Show us the direct link, the smoking gun, that connects President Duterte's words to a specific crime happening on the street.
So what about all those really infamous violent speeches we all heard about? Well, the defense is trying to reframe them. They're saying this wasn't criminal incitement, it was political performance. Kaufman calls it hyperbole and bluster. You know, the tough-on-crime talk of a very unique political figure designed to scare criminals, not to act as a direct command to kill.
And this really sharpens the focus on the core question of the entire case. The defense is essentially asking, where's the proof? Can the prosecution draw a straight, unbroken line from a speech the president gave to a trigger actually being pulled against a specific person?
The defense says that to really prove a direct link, the prosecution needs to show what they call a classical chain of command. But they argue those crucial steps are just missing. There's no evidence, they say, of Duterte giving a direct order to a specific person who then went on to commit one of these murders.
And this is the defense's mic drop moment. They claim that after sifting through thousands of hours of speeches and terabytes of data, the prosecution has failed to connect a single one of the president's statements to any of the 78 victims in this case. That direct causal link, they argue, it's just not there.
Now, besides arguing that there's no smoking gun, the defense also launched a full-on assault on the very pillars of the prosecution's evidence, everything from their witnesses to their statistics.
Kaufman went right after the credibility of the prosecution's insider witnesses. I mean, he called them ruthless criminals and self-avowed murderers. He alleges they're only testifying against Duterte to get protection or immunity for their own crimes. He even argued that relying on their testimony is morally repugnant.
The defense also got into some very sophisticated legal territory. They brought up a 2024 ICC precedent called the Al-Hassan case. Now, this gets a little technical, but it is so important. It all comes down to how you define the victims of the drug war.
So this legal distinction is make or break. To qualify as a crime against humanity, which is one of the most serious charges you can face in international law, an attack has to target a civilian population. The defense is arguing that the drug war didn't target everybody, the general population, but instead a specific subgroup of alleged criminals. And if the court agrees with that distinction, the whole charge could just collapse right there on a technicality.
Then, in a pretty provocative move, the defense used data from the University of the Philippines' De House project. And what they showed was that drug-related killings stayed sky high, and in some cases even went up, after Duterte left office. Their point? This is a deep-rooted, persistent problem in the Philippines, not some unique policy that started and ended with the Duterte administration.
So, after all these arguments, where are we? Well, the final decision now falls to the 3 judges of the pre-trial chamber. And believe me, the stakes could not possibly be higher.
And remember, all of this is happening while the defense continues to challenge the ICC's very right to even hear this case. They're still arguing that Philippine courts can handle it, that's the complementarity principle, and that the ICC's jurisdiction ended when the Philippines left the court back in 2019. These are the big-picture legal battles framing this entire thing.
And now we have a timeline. The judges are expected to hand down their decision within 60 days of the hearing's end. That's the moment of truth for this whole stage of the case.
The outcome is pretty simple and really profound. If the judges find there are substantial grounds to believe these crimes happened, the case goes to a full trial. If they don't, the charges are not confirmed, and this long chapter of the ICC's investigation could just end.
And that leaves us with the big, final question. By challenging the evidence, by reinterpreting key words, and by questioning the very basis of the whole investigation, has the defense managed to create enough doubt to stop this trial before it can even begin? I guess we'll find out in about 60 days.